April 2023. One drunk driving crash would change everything for Sears Putoski, the wife of Michigan State Trooper Charles Sears Putoski. She was convicted and sentenced to 18 months in prison, but the case took a shocking turn when her husband testified on her behalf. Prosecutors now allege that the trooper lied under oath during her trial. Then investigators uncovered something even more suspicious. They say Trooper Putoski was caught reviewing another officer's body camera footage before his own trial. Why was he studying that recording? Was he trying to make sure his story matched the evidence? Now, as he faces his own perjury case, prosecutors are seeking to add another charge. A state trooper sworn to uphold the law is suddenly fighting allegations that he broke it himself. So what exactly did he say under oath, and what was he trying to hide?
It's Your Honor, we believe that this is not exactly connected to the same transaction. We believe that the count that people would like to add relates to statements made to an officer. So far, the defendant has been charged with 2 counts of perjury for statements that were made during testimony at his wife's trial. An obstruction of justice charge for statements he made to Prosecutor Al Atwood in February of 2024. And now I believe the intent is to add an additional count for statement made by the defendant to an officer. We believe that this addition of an obstruction count is just retaliatory because the defendant has chosen to exercise his right to proceed to trial and not to take the plea offer, yet that hasn't been charged initially. The people have initially charged the defendant with a count of perjury and a count of obstruction. Then when he refused to waive his preliminary examination without having a full copy of the transcript, they added another count, amended the complaint in December to add another count of perjury. Then when he chose not to take the plea offer, they're now moving to add an additional count of obstruction prejudicial to the defendant. Because this is now 4 weeks before the trial, which would interfere with his right to a speedy trial. And he shouldn't be put in a position to choose between an effective defense and to exercise his right to a speedy trial just because the prosecutor failed to add a count about which they had information since the inception of this case. So for these reasons, we would ask that the motion be denied.
The judge sides with the state, meaning the new obstruction charge will stand. For the defense, that's a major setback, but the real battle hasn't even begun. This case is no longer just about one trooper's testimony. Now it's about who will judge him. The original DUI case involving his wife was presided over by Judge Hamlin. After hearing Trooper Sears Putoski testify, the judge reportedly raised serious concerns about his credibility. Now, with Putoski facing his own perjury trial, his defense plans to call Judge Hamlin as a witness. But here's where things get complicated. The judge assigned to preside over Putoski's new case, Judge Elsenheimer, works closely with Judge Hamlin in the same small circuit. That raises a serious question. Can this trial truly be separated from the case that first put the trooper's credibility under scrutiny? And if you enjoy this kind of courtroom content and appreciate the work that goes into these videos, consider sending a super thanks. It really helps support the channel and keeps me motivated to bring you more courtroom stories.
Right, the question before the court is a motion from the people to remand this matter back to the district court to allow for a preliminary examination to an additional charge of obstruction of justice with regard to the defendant. Question is, of course, a matter of discretion, not only to the court, but the extent of the discretion that is accorded to the people to actually make decisions regarding charging. The court has to respect that discretion. As far as I'm concerned, the broad discretion that the law gives the elected prosecutor or the appointed prosecutor in this case does outweigh the concerns that the defendant has with regard to retaliation. The plaintiff does have the control, if you will, of the substance and matters contained in the information, and will be allowed to amend the information or amend this matter to the district court. All right, let's go ahead and take up the other motion that's been filed, this one by the defense, and this is a motion to disqualify this court based upon the potential of the court's colleague to be a witness in this matter. Let's go to you, Ms. Pop, if you'd like to make your argument.
So as the court is aware, the defendant is charged here with 2 counts of perjury and will be on 2 counts of obstructions. The counts regarding the perjury refer to testimony that he provided with on the first panel during his wife's trial in 2025. And the obstructions relate to statements that were made to prosecutor Kyle Atwood. The defendant intends to call Judge Hamlin as a material witness in his case regarding contested facts in this case and regarding testimony that the defendant provided, as well as the testimony that Judge Hamlin would have to provide testimony pertinent to the defendant's motion to dismiss the perjury counts, as well as maybe testimony that the defendant will offer at the trial with an entrapment defense. And this includes testimony from Judge Hamlin regarding the defendant's testimony, but as well as conversations that Judge Hamlin has had with the prosecutor. So when a professional relationship exists between the presiding judge and a material witness, such as a judicial colleague, it can be reasonably inferred that there is a high probability of bias on the part of the judge. We did attach a State Bar of Michigan's ethics opinion that noted that if a judge is a necessary witness, then there could be an inference of bias on behalf of the presiding judge. And here, Judge Hamlin is a necessary material witness. This qualification is necessary when a judge is biased or prejudiced, but also when there's an objective and reasonable perception that there's a serious risk of actual bias. Of course, the judge is not automatically required to recuse himself solely because a colleague is testifying, but he must recuse himself if his impartiality may be reasonably questioned or if there's an appearance of impropriety. So we believe that that could exist here. And if a colleague is a necessary witness regarding a contested fact, like here, then the need for recusal is a lot more obvious. And the nature of the relationship could have an impact on this as well. If the presiding judge is close to the testifying judge in the same small chamber, the impartiality concern is even greater. And here we have a very small chamber with 2 judges who serve on 3 different counties that work very closely together. And if another judge is available, assigning a different judge seems to be the easy and best solution to avoid any issues. We have alternative options here. We have judges that could preside over this trial to protect the public's confidence in an unbiased judiciary and to protect the court and the parties from unnecessary appeals in this matter. Also, in light of the motion to dismiss that we have filed, which alleges prosecutorial misconduct that is so severe that we believe a dismissal is warranted, and because of the close relationship between the bench and the prosecutor's offices here, there's just a lot going on in this matter, and we believe recusal would be appropriate.
I believe the court can be unbiased and preside over this matter, and so therefore I'm asking you to deny the motion.
All right, thank you, counsel. Response?
Yeah, and Michigan Rule 2.003C1B does provide a basis for recusal. In this case, it doesn't have to be a familial relationship. The judge, based on objective and reasonable perceptions, has either a serious risk of actual bias impacting the due process right of a party, or has failed to adhere to the appearance of impropriety. I believe this section offers a basis for this recusing item.
All right, I think the filing is timely, number one. I also think that there is a basis for the request in the court rules So I appreciate the procedural arguments being raised by the defense, by the people. But I do think that this is an appropriate motion to be filed, and it was properly filed. The argument is that because of the close relationship between this court, me, and as chief judge in this circuit, and my colleague, Mr. Hamlin, Judge Hamlin, who is the presiding judge in the underlying matter involving the defendant's wife, which led to the genesis of the charges that have been brought against this defendant, that there is at least the appearance of impropriety potentially, such that public confidence would be supported should this court grant the motion from the defense and step aside and allow the Supreme Court to appoint another judge.
This is where legal principle meets an uncomfortable reality. Under Michigan court rules, a judge may not need to prove actual bias before stepping aside. In some situations, even the appearance of a conflict can be enough to justify recusal, and that's what makes this case so complicated. The defendant is a state trooper, one of the key witnesses is a sitting judge, and the judge assigned to hear the case has an ongoing professional relationship with that same witness. So legally, the question isn't simply, is Judge Elsenheimer actually biased? The bigger question is, would a reasonable person looking at all these connections question whether he could remain completely impartial? That's not just a minor technicality. In a case involving allegations that a law enforcement officer lied under oath, public confidence in the courtroom may be almost as important as the final verdict. Because when trust in the process is questioned, even a legally correct decision may leave people asking one thing: was the trial truly fair?
To hear the matter. The court does maintain a very close relationship with Judge Hamlin, as one would expect. We work very hard. We communicate together regarding cases. The court does provide guidance at times to Judge Hamlin in the same way that Judge Power provided guidance to this court when I started 10 years ago. And frankly, Judge Hamlin provides guidance to me on criminal matters because he's such an expert on occasion. So we do have a very close working relationship that I think is certainly well known to the bar in this community, and frankly, I think expected by this community as well. With that said, the court feels confident that it can act with impartiality in this matter. But I do also think that the fact that we're talking about a sitting judge who is my charge, if you will, as chief judge, whose credibility could be called into question, certainly as part of the motion practice that's been filed and adjourned, that there is a sufficient issue to justify this court stepping aside and allowing the Supreme Court to identify another judge to handle this matter. Very concerned, given the fact that we're talking about a member of the state police who's been charged with these serious crimes. We're talking about witnesses that include members of the prosecutor's office here in Grand Traverse County. We're talking about witnesses that include a sitting member of this bench that the public should have full faith in the process going on, and shouldn't even have an inkling, a sniff that there is something afoot beneath the system or behind the curtain that is resolving this matter in advance of a fact finder ultimately making a decision at trial or whenever this matter is ultimately decided. To preserve that confidence in the system, I do think that the wisest course here is for this court to do exactly that. I'm going to grant the motion. The court will go ahead and notify the Supreme Court Administrator's Office to find another judge to sit in this matter. That judge will be appointed most likely next week.
If you've enjoyed this courtroom story and appreciate the work that goes into these videos, consider sending a super thanks. Your support helps the channel keep bringing you more detailed courtroom cases and documentary-style stories. And if you're interested, I've also added a few products below. Feel free to check them out. In the end, Judge Elsenheimer makes the harder call. He steps aside not because he admits to being biased, but because he recognizes that the public deserves a process free from questions about personal or professional connections. A new judge is expected to take over Trooper Charles Sears Putoski's case, but the biggest questions remain unanswered. Did he really lie under oath to protect his wife? Why was he reviewing another trooper's body camera footage? And when Judge Hamlin eventually takes the stand, will his testimony help the defense or make things even worse? This video covered the pre-trial battle over which judge should hear the case. The real fight, truth versus perjury, still lies ahead. If you found this case interesting, hit the like button, share your thoughts in the comments, and subscribe for more courtroom cases and documentary stories.